Hello and welcome to our newest tool for professionals working with destitute EU migrants. This is a series of 4 training modules on EU free movement, designed for professionals working to protect and promote the rights of destitute mobile EU citizens. Each module focuses on a particular topic. The current module, number 1, introduces us to the concept of free movement and discusses the right to reside in another member state in the EU. Module number 2, which comprises 2 sections, presents the statuses which allow an EU citizen to reside legally in a host member state. Module number 3 addresses the right to welfare benefits for destitute EU migrants. And finally, in module number 4, we discuss what are the grounds for expulsion of EU citizens from a host country. We hope you will enjoy the modules and find this tool useful. In this first training module, we will look at the main concepts around EU free movement, and we will discuss the parameters of the right to reside for EU citizens and their family members. The first thing we need to answer is, what is the European Union? How would you define it? The European Union, abbreviated to the EU, is a political and economic union of 27 member states. Next, what is free movement? The EU has developed an internal single market. This means that there is a common market between the member states of the EU. This common internal market seeks to guarantee the free movement of goods, capital, services, and persons. Persons includes workers and other EU citizens. The free movement of persons means that EU citizens can move freely between member states. This freedom enables citizens of one member state to travel to another, to reside and to work there, permanently or temporarily. During the first 3 months of their stay, citizens can be present for any reason, including leisure, tourism, healthcare, work, study, or family reasons. Access to the single market also extends to the territories and citizens of Switzerland, Iceland, Norway and Liechtenstein, which are not members of the EU. The United Kingdom left the EU single market in December 2020. Let's look at which rights are associated with free movement. The main free movement rights the European Union grants to its citizens are 1. The right to move to another member state. 2. The right to reside in another member state. This means that not only do EU citizens have the right to move to another member state, they also have the right to stay there. They can stay without conditions during the first 3 months and under certain conditions beyond 3 months. This right to reside, as we will see in detail later, protects citizens against unlawful expulsion by the host member state authorities. 3. The right to return to their member state of origin and to re-enter a member state they have left. 4. The right to access welfare benefits in the host member state, under the same conditions applied to nationals of that member state. This right to equal treatment exists only for mobile EU citizens who are legally residing in the host member state. Again, we will look in more detail later at what the conditions are for legal residence in another member state for periods longer than 3 months. The EU has adopted a complex set of rules to guarantee EU citizens' right to free movement. The main piece of legislation overseeing this is the Citizens' Rights Directive. Each member state has to transpose the rules, and particularly the rights contained in this directive, into its national legislation. This may take the form of a law, a decree, an order, or other types of legislation. As we have said, member states must transpose the directive on free movement rights into national legislation and have to apply these rights in line with EU law. If a law, a practice by the authorities, or an interpretation by judges goes against the directive, this is a violation of EU law. A violation of EU law may be challenged at national or EU level. It is therefore really important that you are able to recognise cases where national authorities denying mobile EU citizens EU-level free movement rights is in contravention of EU law. These authorities may be, for instance, job centres, immigration officers, or social services. We will look at some case studies later on that will help you identify these instances. So, who are the beneficiaries of free movement? The right to free movement applies to mobile EU citizens, but also to their family members. Being a family member of a mobile EU citizen is particularly important for third country nationals, abbreviated as TCNs, and for EU citizens who do not have an autonomous right to reside in the host member state. This means EU citizens who don't have a regular immigration status in the host member state. It is therefore essential that we understand who is a mobile EU citizen and who is a family member. Let's look at the conditions to fulfill to be considered a mobile EU citizen. There are two cumulative conditions. This means that both conditions must be satisfied. The first condition is holding EU citizenship. This means being a national of an EU member state. Third country nationals are not EU citizens because they are nationals of countries outside the EU. We will see later that in some cases, third country nationals may enjoy free movement rights if they are family members of EU citizens. The second condition is having moved between member states. The person must have moved from her or his member state to another one. This could be a person currently living in a member state other than their country of origin, for example, a Spanish person living in Germany, or someone who used to reside in another member state and then return to their member state of origin. For example, a French person who had been living in Italy and returns to France. This condition is very important because an EU citizen that does not move to another member state does not enjoy free movement rights. We will call EU citizens who have moved mobile EU citizens. We have said that family members of mobile EU citizens can also enjoy free movement rights. But who is a family member of an EU citizen according to the directive? The answers are the spouse or registered partner of an EU citizen, the children under 21 or the dependent children of an EU citizen and of their spouse. This means that children that are the sons and daughters of just the spouse, even if the spouse is a third country national, are also family members. The dependent parents of an EU citizen or of their spouse. As you can see, just having family ties is sometimes not enough. To be regarded as family members, parents and children over 21 must be dependent on the EU national. We will see some examples of what being dependent means later. In addition to these three categories of family members recognised by the directive, the Court of Justice of the EU also recognises as family members third country nationals who are the primary carers of EU children. This means that third country nationals enjoy residence rights in the host member state if their children who have EU citizenship are dependent on them. Earlier, we said that free movement rights only apply to mobile EU citizens, that is, EU citizens who have moved from their member state to another. The same applies to family members. They only enjoy free movement rights when they accompany, i.e. move together within the EU, or join from outside the EU, a mobile EU citizen, that is, an EU citizen who has previously exercised her or his right to free movement. Let's see this with practical examples. A citizen of Morocco is married to a Spanish person. Morocco is not an EU member state, and therefore a Moroccan national is not an EU citizen. They are a third country national. In this case, the Moroccan national is the spouse of a Spanish person and is therefore the family member of an EU citizen. But is the EU citizen, their Spanish spouse, a mobile EU citizen? Has that person exercised their right to free movement? We can imagine two different cases. Either the Spanish citizen is living in Sweden and the Moroccan national joins their spouse there. Free movement applies. The case is governed by the EU legislation around family members. Or the Spanish citizen lives in Spain and has not exercised the right to free movement because they have never moved or lived in another member state of the EU. In this case, the EU legislation on free movement does not apply, and the Moroccan national can only join their spouse in Spain if this is possible under Spanish law. So is there a difference in treatment, or isn't there? It may be the case that mobile EU citizens enjoy more favourable treatment than non-mobile citizens as regards family reunion. It is up to national law to make sure that citizens that have not moved enjoy the same rights as mobile EU citizens. Earlier, we said that the only persons that are regarded as family members without conditions are the spouse and children under 21 of an EU citizen or of their spouse. On the contrary, children over 21 and parents only enjoy free movement as family members of an EU citizen or of the spouse of an EU citizen when they are dependent. So, when are family members regarded as dependent? In principle, this is when their material support is provided by the EU citizen or by the spouse or partner of the EU citizen. Let's look at some practical examples to clarify the free movement rights enjoyed by family members. Let's start with a case study on children under 21. May a 7-year-old Moroccan child join their mother, who is married to a French person and is living with her spouse in Belgium. Let's take the case of Aziz. Aziz is 7, is Moroccan and resides in Morocco. He is the son of a Moroccan woman who is married to a French person and is living with this person in Belgium. The first thing to check is whether free movement applies. The French spouse is living in Belgium and must thus be regarded as a mobile EU citizen. This means that EU free movement rules apply. Aziz is under 21 and therefore he is automatically a family member of the spouse of the EU citizen. He can therefore enjoy free movement rights and join his mother in Belgium. Let's move to a case about a child over 21 who is not dependent. May a 25-year-old Moroccan join their mother who is married to a French person and is living with her spouse in Belgium? The answer is only if that person is dependent. Karim, Aziz's brother, is also a Moroccan citizen, is 25 years old and also resides in Morocco. Karim works and is not supported by his mother, so cannot be regarded as a dependent family member. EU free movement rules do not apply. To join his mother in Belgium, Karim must rely on Belgian immigration rules because he does not enjoy free movement rights as a family member. Let's now examine a case about a dependent parent. May a Chinese mother join her son, who is married to a German and living with his spouse in Sweden? Li, a Chinese national, is married to a German woman, and both are residing in Sweden. Mrs. Jia, Li's mother, a Chinese national residing in China, relies on the financial support of her son and his wife to pay her living conditions. Free movement applies because the German spouse has moved to another member state and is residing there. Mrs. Jia can be regarded as a dependent family member of an EU citizen, and she is therefore entitled to apply for a residence permit and join her son in Sweden. So far, we have looked at the concepts relevant to mobile EU citizens and family members that enjoy free movement rights. Now it is time to see how free movement works in practice. We said earlier that EU citizens and their family members may move to another member state and decide to live there. There are 3 main periods of residence in the host member state that are taken into account. The first 3 months. During this time, all EU citizens and their family members can stay in the host member state without conditions. Between 3 months and 5 years, this period is called temporary residence. During this time, only EU citizens whose status means they are regularly residing and family members of EU citizens that have this status can stay in the host member state. After 5 years. After 5 years of legal residence, EU citizens and their family members can become permanent residents of the host member state. As we have said, the right to move to and reside in another EU member state may be exercised without conditions for up to 3 months. but which documents are required for a person to reside for up to 3 months in another member state? EU citizens must only show a valid identity card or passport. Visas or other equivalent formalities are not required for them to exit and enter EU member states. Third country nationals who are family members of EU citizens can only move with a passport and may be required to obtain an entry visa as well. It is up to each member state whether or not they impose a visa requirement on them. If it is required, the visa must be granted free of charge and without delay. For instance, taking longer than 4 weeks to issue a visa to third country national family members has been ruled unreasonable. Whereas a valid identification document is enough for EU citizens to stay in another member state during the first 3 months, the situation changes after 3 months. After 3 months, only EU citizens that fulfill certain conditions have the right to reside. Beyond the first 3 months of presence in the country, only EU citizens that are legally residing in the host member state retain the right to stay there. What do we mean by legally residing in the host member state? Essentially, this means having a specific status that, in the view of the EU legislator, allows the person to integrate into the host member state and to participate in the host state's economy without being an unreasonable burden on the country's welfare system. Let's look at which statuses allow a person to reside legally in the host member state beyond 3 months. Mobile EU citizens that are regarded as legally residing after 3 months are those who are economically active. This includes workers, self-employed people, people who have retained worker status or self-employed status, and job seekers. Self-sufficient persons. This means economically inactive persons with sufficient resources to support themselves and sickness insurance. Students. Students are regarded as economically inactive too and must provide proof of sufficient resources and sickness insurance. Family members of an EU citizen falling into one of the categories we've just listed. These are the only statuses that allow EU citizens to reside legally in another member state beyond 3 months. As you can see, in principle, to be able to stay longer than 3 months, EU citizens must work or have enough money to support themselves in the host member state. In the next module on the statuses granting legal residence, we will go into more detail on the parameters of these concepts. So, how do member states check whether citizens from other EU countries are legally residing on their territory? Mobile EU citizens and their family members may be asked by the host member state to report their presence on the territory within a reasonable period and not less than 3 months after their arrival. This means that member states can also decide not to impose a registration system, as is the case in Germany. This does not exclude the power to check whether mobile EU citizens are legally residing on the member state's territory, for example, in the case of random checks or when assessing somebody's right to welfare benefits. When a member state decides to impose a system of registration for mobile EU citizens and their family members, as is the case in Belgium, for example, its national authorities must provide mobile EU citizens with a residence certificate immediately upon request, after verification that that person fulfills the conditions for regular residence. This residence certificate has a validity of 5 years from the date of issue. TCN family members of mobile EU citizens with a residence card within 6 months of the request. This residence card has a validity of 5 years, but might expire in the event of prolonged absences. The validity of this residence card cannot be affected by temporary absences not exceeding 6 months in the space of a year, or by absences of a longer duration for valid reasons. For member states that decide to impose a registration system for mobile EU citizens staying longer than 3 months, the EU has provided a list of documents that can be requested upon registration. The documents to be presented to the authorities in order to be registered essentially depend on the person's claim to legal resident status in the host member state. As well as presenting their identity card or passport in order to be registered, mobile EU citizens staying longer than 3 months must provide the following documents that prove their status. Workers have to provide a certificate of employment, and self-employed persons must show a document proving their self-employment. Persons with sufficient resources must provide evidence of having sufficient resources and sickness insurance. Students must give proof of enrolment, a declaration of sufficient resources, and proof of sickness insurance. Family members must provide proof of their family relationship and the registration certificate of the EU citizen they are accompanying or joining. Job seekers, during the first 6 months of their stay, must only produce a document proving their registration with the job centre. If they are registering after 6 months, they also have to provide evidence of their job-seeking activity and of having a genuine chance of being employed. After you have done the next module, where we will clarify what all these statuses stand for, it will be easier to understand and to remember the different free movement rights EU citizens enjoy depending on their status. We are going to be discussing what the conditions are for being regarded as a worker, a job seeker, or a person with sufficient resources. We have just seen which rules the EU sets for member states wishing to impose a registration system. The idea behind the directive is that the registration requirements that national authorities put on EU citizens place as little a burden on them as possible. Let's see how registration works in practice in a member state where it is compulsory for mobile EU citizens to register after 3 months of presence. In Belgium, EU citizens and their family members, third country nationals, or EU citizens who do not have a status that allows them to reside legally, must register with the local authority where they decide to live within 3 months of their arrival in Belgium. In practice, many people live in Belgium without registering. However, registration is often necessary to be able to sign a work contract, to apply for welfare benefits, or to ask for family reunification. So, who decides on the registration and checks the documents listed above to prove the person's status? In Belgium, the task is shared between the local authorities, municipalities, and the Immigration Office. Municipalities generally handle easier cases where EU citizens can show proof of work, self-employment, or enrolment on a course of study. Cases that are regarded as more complicated, such as job seekers, self-sufficient persons, or those who rely on another person for their means of subsistence, will be handled by the Immigration Office. After 5 years of legal and continuous residence, mobile EU citizens and their family members may make their decision to stay in the host country a permanent one. Provided that they have been residing there legally and continuously for 5 years, they may register in the host member state as permanent residents. We will come back to the concepts of legal and continuous residence shortly. For now, let's see what EU citizens, their EU family members, and their third country national family members are entitled to after 5 years. Again, the conditions for permanent residence are different depending on status. EU citizens and their EU family members may apply for a permanent residence certificate that must be delivered immediately upon application. We say immediately, but this document is in fact only delivered once the national authorities have verified the duration of the person's legal residence. Third country national family members may apply for a permanent residence card, and this document must be delivered no later than 6 months after the application. What are we seeing here? What is the difference between having a temporary residence permit between 3 months and 5 years and permanent residence delivered after 5 years? Permanent residents no longer have to provide evidence of being economically active or of having sufficient resources. They can stay in the country for as long as they wish without having to prove anything, and they can fully access the welfare system of the host member state on the same terms as nationals of that state. The right to reside for a temporary residence is linked to their status. If they lose their worker status, for instance, because they lose their job, they also lose their right to reside. On the contrary, once acquired, the right to permanent residence can only be lost after an absence from the host member state for a period exceeding 2 consecutive years. We said earlier that only mobile EU citizens that have been legally and continuously residing in the host member state for 5 years can acquire permanent residence. But what do we mean by legal residence? This means that the person in question has been residing in the host state under one of the statuses for regular residence after 3 months, such as being a worker, for all 5 of the years they have been living there. It may also result from a combination of the statuses for regular residence. For example, if an EU citizen entered the host member state as a student or a job seeker and then found a job, the member state will take both periods into consideration when calculating the 5 years of legal residence. And what does continuous residence mean? It means that during the 5 years, the person's legal residence in the member state must be continuous. However, absences are still possible for travelling abroad, visiting family members in the member state of origin, etc. The main rule is that the continuity of residence up to 5 years needed to acquire permanent residence is not affected by temporary absences. This means that temporary absences do not stop the clock. An absence is regarded as temporary when it does not exceed a total of 6 months in a year. Longer absences, up to a maximum of 12 consecutive months, are permitted and do not stop the clock for important reasons such as pregnancy and childbirth, serious illness, study or vocational training, or being posted to work in another member state or third country. Longer absences mean the residence has not been continuous. We have reached the end of this module. In the next module, we will go into detail about the statuses granting legal residence that allow EU citizens to stay in the host member state beyond 3 months. Thank you for listening.